application and appeal in the matter of Fowell and Birmingham City Council.
Yes, Mr. Bannon.
My Lord, may it please you, I appear with my learned friend Miss Steele on behalf of the local authority appellant. My learned friends Mr. Narby and Mr. Marcus appear for the respondent, Miss Griffiths Fowell.
Thank you.
My Lord, this morning we've handed up a small bundle of authorities on the point that court asked us to address first yesterday.
Yes, is that here? Yes.
Namely the question of whether this appeal is academic.
Thank you. Yes.
It's the local authority's position that the appeal is not academic, and that in fact none of the none of the pleaded grounds of appeal has been rendered academic by anything that's happened since the judgment given by His Honour Judge Rawling in the court below. I don't know whether the court would prefer me to address the point first as appellant, or whether it would prefer to hear from the respondent just on this point first, on the basis that it seems to be their argument that matters have become academic.
Well, I've read the skeleton arguments for this appeal, and the respondent's skeleton argument doesn't say very much at all on this topic, and largely, as I understand it, adopts what you say. And so my view is that you should start on this.
I'm happy to do that, my Lord. The appeal in this case, as the court is aware, concerns the making of a mandatory order by the court below in relation to a duty to secure suitable accommodation for a homeless household. We have raised 6 grounds of appeal.
When you say mandatory order, that's the final mandatory order.
The final mandatory.
Not the interim one.
Yes.
The subject of the consent procedure.
Yes.
Thank you. Sorry.
No, not at all. My Lord, if I just summarise the effect, if I may do so, of the grounds that have been raised. There are, in my submission, essentially 2 groups of grounds. One group raises the question whether the local authority had already performed its accommodation duty by securing suitable accommodation. And grounds 4, 5 and 6 go to that question. I'm calling those for convenience the suitability grounds.
Sorry, which grounds?
4, 5 and 6.
Thank you.
The other 3 grounds, grounds 1, 2 and 3, raise the question of whether the accommodation duty had ceased to be owed altogether by the time the case came to be heard. And I will refer to those as the discharge of duty grounds. Those discharge of duty grounds raise one issue of statutory construction, namely whether the ground relied on for the asserted discharge of duty was in fact legally available to the local authority. The other 2 of the discharge of duty grounds raise the question of whether the court should even have entertained the argument as to whether the duty had been discharged, and if it was entitled to do so, what were the principles on which it should have reached its decision. We say there was an alternative remedy which should have been required, which the respondent should have been required to use, but if the court was going to entertain it, the learned judge below erred in effectively deciding the issue on the merits rather than on judicial review principles. Those 2 grounds of alternative remedy and judicial review principles also apply to the suitability ground. In other words, we say the judge shouldn't have entertained it at all, but if he did, if he was entitled to, he should have considered it on judicial review principles and failed to do that. But it also raises the construction of a letter that the local authority wrote whether that letter had the effect of admitting that the property offered was unsuitable, or whether it had a different effect, which is what the appellant contends. With that introduction, the first argument that we put forward is that the claim is not academic for three reasons.
The appeal is not academic.
Sorry, the appeal is not academic. The first reason is that His Honour Judge Rawlings' decision in November, when making the final mandatory order, was that the accommodation secured by the local authority for the respondent was not suitable and had at no time been suitable, and that therefore the council was wrong about that. But the effect of that finding is essentially that his ruling was that the authority was in breach of His Honour Judge Williams' order in June, the interim mandatory order, because that order required suitable accommodation to be provided, and Judge Rawlings held that suitable accommodation had never been provided. And that, we say, is directly relevant to the committal proceeding.
Is this still your first point?
Yes. The committal proceedings which allege that the council is in breach of a mandatory interim order made by Judge Williams. The council would like to be able to argue in defence to that it was not in breach of Judge Williams' interim order because it secured suitable accommodation. The finding or the ruling by Judge Rawlings in November that we had never achieved the provision of suitable accommodation, plainly in our submission, cuts across that argument, prevents us essentially from raising that argument, we would say, because it's the subject of Judge Rawlings' finding. And we say, well, if Judge Rawlings approached it in the wrong way, then this court might decide that he should not have made that ruling. And if he should not have made that ruling, and this court does not uphold his decision, then that will necessarily, in our submission, assist the council in defending the committal proceedings.
But are the committal proceedings being pursued?
Yes. My Lord, at a case management hearing in March of this year, Judge Rawlings, who was also hearing those proceedings, stayed them pending this appeal on the basis that he thought the outcome of this appeal might materially affect the committal proceedings. So they are currently stayed, but they are still being pursued.
I think in addressing this on whether the appeal is academic or not, what you haven't done yet is actually outline to us what the current position is.
No, I haven't, my Lord, I apologise.
No, it's just...
Current position is, as I understand it, that my Lords will be aware that there was a property at 7 Holden Close, which was the subject, the principal subject of the argument at the time of the hearing below. Works to that property to adapt it were ongoing in order to render it suitable for the long term. Currently, my understanding is that the respondent is living elsewhere, but is still asserting...
Is that still the Windrush accommodation?
No, I think it's another
Okay.
set of accommodation, my Lord.
Well, look, I wonder if I may insist.
Yes, of course.
So the respondent is currently living in one room in a house in multiple occupation on an insecure license, which is terminable on 7 days' notice. She's made a further homeless application without prejudice to her contention that the housing duty, main housing duty, is owed to her. There has been no decision on that application. My solicitors then sent a pre-action letter saying, why has there been no decision?
When was the application?
The application was in April.
Right.
My apologies, I didn't. Sorry, 24th, I'm wrong, 24th of March 2026. And her household has changed, as my lord, you may have gathered from the papers, in that she became engaged on Christmas Day, and she wishes to live with her fiancé, although they are not presently living together. He is living in another room in the same house in multiple occupation. So that's the position as far as the respondent is concerned. She's awaiting a decision on her without prejudice homeless application. As far as her brother is concerned, he's not directly relevant in this appeal, but he is currently in Rowley Regis Hospital.
When you say not directly relevant, you mean not relevant?
Yes, because at the time of the judge's judgment, he and the respondent were living together. Subsequently, the respondent now wishes to live with her fiancé, and so
Yes.
that's been a change in circumstances.
Thank you.
Grateful to my learned friend, my lord. What, as I understand it, my learned friend describes as a room in an HMO on a insecure licence is in fact supported accommodation, which she is in, which is conventionally provided on an excluded licence basis because it requires the person accommodated to comply with the requirements for support until they no longer need it. So in my submission, the important point, however, is that as my learned friend confirmed, she is still asserting that she is owed a duty as a result of the application that is concerned in this appeal.
We'll save that with the very important changes in the circumstances of what constitutes the household. Her brother is not. Her fiancé, maybe.
My lord, yes, but the position, once the local authority has accepted a housing duty to an applicant, which in this case was the respondent, Miss Griffiths Fowell, mere changes to the nature or the composition of the household do not bring the duty to an end, as we shall see if we get that far, if the court is willing to hear the appeal. Section 193 provides a comprehensive code for when accommodation duties come to an end, and there is no provision within that that says if your household changes its composition, the duty comes to an end and you have to make a new application. It simply affects the nature of the accommodation that you have to be offered.
Quite. Presumably, it does have an effect on what constitutes suitable
Yes.
accommodation. Well,
Yes, it does.
I don't want to curtail your submissions at all, and you must make them in the manner and order in which you think fit. But it may help if I outline some of the concerns that, speaking for myself, I have,
My lord, yes.
which I think you need to address,
Of course.
because you need to persuade us that we should hear this substantive appeal at all. And obviously, if we do, we need to leave adequate time to do that during the course of today.
My lord, yes.
You haven't shown us yet the letter of the 16th of January from the respondent's solicitors.
No.
As I understand it, open correspondence, not without prejudice.
No.
Right. We can look at it if we need to, But the starting point, as it seems to me, is this: that appeals to this court lie against orders, not against the reasons given by a court for making the order. And if authority is needed for that proposition, see Lake and Lake in 1950.
Certainly not controversial.
Thank you. The next point is that the letter of the 16th of January this year, as I read it, made it clear that the respondent did not ask this court to sustain the final mandatory order made by the High Court. So it seems to me that the appeal on the face of it has become academic. Because, and I say that against the background, that, and this is a matter for Mr. Zarnaby to come back to in due course. At the end of his skeleton argument, he asks us to sustain the order below. I don't see how he can do that in the light of the open letter of the 16th of January. That's a matter for him to address. As far as you're concerned, what you've got to persuade us of is that in circumstances where the factual circumstances and what may therefore constitute suitable accommodation may be fundamentally affected by the fact that the respondent no longer wishes to be accommodated with her brother, that somehow we should carry on entertaining your grounds of appeal. That seems to me to be classically academic points. And then you get into the Salem jurisdiction. We have a residual discretion. But although one never wants to be exhaustive about the kinds of circumstances in which the court would consider an appeal which has become academic on its own facts, generally speaking, the court tends to exercise its discretion where, for example, there's a pure point of law, for example, a point of statutory construction, not, for example, where you have to get heavily into the facts of a particular case. However, of course, I understand it's important. Then there are 2 points, as I read your skeleton argument at paragraph 72 to 77, which are no doubt what you're developing at the moment. You say essentially the respondent continues to assert that there is a duty owed to her, and there's still a live issue about suitability. My provisional view is that there is no current live issue between the parties at all. As we've heard, there's a new application which will be determined, no doubt, on its merits in due course. And if anyone thinks that they can challenge that, no doubt they will. You may well be right that there has to be a review of that decision. You may well be right that there has to be an appeal to the county court, and that it was all wrong to embark on judicial review. But all of that seems to me to reinforce the fundamental point that this is all contingent and hypothetical. It's not actually the issues that arise on this appeal against an order which no one actually asks us to sustain any longer. And the second main line of argument you're advancing is that it has potential relevance to the contempt proceedings. But it seems to me, at least provisionally, that that's to do with a past event. There was an interim order in place, and they brought an application for contempt. It may or may not be that the High Court will choose to proceed to decide that. If this court were to say that we think this is all academic as far as this court is concerned, I have no idea what the High Court will then say on the committal proceedings. I understand they've stayed it pending this appeal, but if we were to say that we think this is all academic and we're not going to hear it on its substantive merits, then presumably the High Court would have to consider whether it should continue considering the committal proceedings, which are in relation to a past interim order, which may or may not still have any practical significance any longer. But I don't want to trespass, and this is the fundamental point. This court can't sit here and in its judgment give advice to the High Court on how it should deal with committal proceedings. It would be wrong for us to trespass on its province. So those are the sorts of concerns that I think you need to address us on.
My lord, it might be helpful if I address those now head on,
Yes, please do.
rather than developing the arguments that I was going to raise.
Well, it's entirely up to you.
Well,
I don't want to tell advocates how to do their job. It's a matter for you, but I thought it might just help if you understand what is, at least provisionally, of some concern to the court.
my lord, yes, it's extremely helpful, and that's why I feel it's probably more helpful if I address those points head on, and then if I need to go back to my previous argument, I will do. My lord, the question of what is still at stake between the parties, if anything, which is, as I understand it, essentially one of the areas of concern, I submit, is this. First of all, there is still what I think in the Salem case is described as a list between the parties in relation to the fact that the claimant, the respondent, is pursuing contempt proceedings against the appellant local authority for breach of an order. I accept that that is breach of an interim order. I accept that that interim order has gone away. But in my submission, there is still a dispute between the parties which could result in very real consequences for the local authority if the High Court holds that the authority was in breach of that order. Now, in my submission, that puts His Honour Judge Rawlings' final order in the frame because he declared that the local authority was in breach in substance. And
not in breach of the interim order.
Well, his declaration, which the respondent, as I understand it, is not willing to agree should be discharged. If I can find the right bundle.
A208.
Yes, was to the effect that
Well, there are a couple of orders. This is 27th of November, is it?
21st of November, my lord.
21st, sorry.
This is the declaration that the defendant has been and remains in breach of the main housing duty.
Yes. So,
But you could win on repeal against that, but still be found to have been in breach of the interim order.
well, no, my lord, respectfully, because if we win on the argument that we were not in breach of the main housing duty, the argument must be that the offer of accommodation that were made at the time of the interim order were suitable. That was what the case was about.
You're seeking to win on the basis that this should have gone to the county court.
Well,
And that won't decide the issue at all. That's your primary.
no, it won't decide the issue, but what it will do is remove the block to the point being argued, effectively. Because at the moment, there is a ruling by a High Court judge that the local council was in breach of its statutory obligations under the Housing Act. The interim order required them to perform those obligations. The ruling, therefore, and the declaration that they breached those obligations is, in substance, exactly the same thing as saying they breached the interim order. Because that is what the interim order required them to comply with. So while I accept entirely my Lord Justice Phillips' point that if this court says the judge shouldn't have entertained it at all, or should have done it differently, and therefore the fact that he didn't render his decision wrong, does not say we're right, it clears the ground for us to be able to raise the argument.
You mean we could in those circumstances discharge the declaration, and so at least you would be starting with a neutral position in the contempt proceeding. Is that your argument?
Yeah.
Whereas at the moment you're not starting on a neutral footing. You've got an obstacle in your way.
Yeah.
Because one of the things that Mr. Zappi would say in the contempt proceedings is you can't go behind the declaration. Right?
Is it relevant to be aware of when the contempt proceedings were started? Because presumably the breach of the interim order complained of in that application must have predated the making of the application.
The breach.
When were the contempt proceedings started? Because it was pretty swift.
Yes, it was.
17th of July, I think. The order required compliance by the 16th of July.
Yeah, and I've read the witness statement which was filed in support of that application, and correct me if I'm wrong, but I understood both the application in its formulation and the witness evidence in support of it as dealing with the circumstances as then existed.
Yes.
It might be said, and I have to be careful what I say, because we do not want to trespass on the province of the High Court in future contempt proceedings,
No.
whatever the outcome of this appeal. But one possibility is that the High Court will take the view that a lot of water has passed under the bridge since then. And I also bear in mind that one of the principal purpose of a civil contempt application is not punishment, it's to secure compliance with the court's order. So one view of what's happened is that it's all a long time ago, and that's become academic.
My Lord, that may be one view. I entirely accept that's one view, and that's plainly one view that the local authority would be seeking to pursue. But it's also possible that another view would be that committal proceedings having been instituted, the judge in November having concluded that the duties with which His Honour Judge Williams had required compliance had not only not been performed by the 16th of July, but still remained unperformed by the 21st of November, rendered the breach a particularly serious one. Judge Rawlings was quite clear in his judgment as to the reasons why he rejected the claimant's argument, the local authority's argument, that the accommodation offered was suitable. And as you know, obviously, one of the arguments we raised is that he should never have entertained a merits-based approach to deciding that, but he did. And so the order that he made, which is in reliance on that approach, is one that we respectfully submit, even though it was all a long time ago, even though the proceedings commenced before he even heard the final application for a mandatory order, is still one that follows the local authority around, and will follow the authority around. And it will do so not merely in relation to the contempt proceedings, but also in relation to the fact that the respondent continues to assert that she is owed a housing duty by the local authority pursuant to the previous acceptance of that duty in the proceedings that are in issue in this appeal. She has made a new application. My learned friend described it fairly as having been made without prejudice to her contention that she is still owed a duty under the previous application where a duty was accepted and she said not performed. Now, that's important in my opinion because the other side of this appeal is the authority's contention that that duty came to an end in August, September time, when she moved out, and therefore voluntarily vacated the accommodation provided. And that therefore not only by the time His Honour Judge Rawlings heard the final application and made his decision, but also today's no further duties are owed under that application. And the authority would be entitled to take into account that she gave up accommodation previously provided in deciding whether it was obliged to entertain her new application. There's a line of authorities from this court that an application made on the same facts as one which was previously discharged doesn't need to be reconsidered by a local authority. Now,
to me, I'm sorry to interrupt you. To me, this has an air of unreality about it, because the facts have fundamentally changed. Now, I don't make any pronouncement on the merits of any, or what the current situation is, and what any future decision will be. But the facts are fundamentally changed. And therefore, what accommodation is suitable, and therefore what accommodation must now be provided, just can't be determined by what the facts were a year ago, for example. Is that too simplistic a way of looking at it?
in my submission, homelessness law is not always the most logical
Right.
and straightforward. Hence, I suspect one of the reasons why it takes up so much of your lordship's time in this court. One of the things that is still affecting the local authority and indeed the respondent is the question of whether a duty to her is still owed. If it is, she doesn't need to make a new application as a homeless person. She simply needs to say to the local authority, my situation is household has changed, and I require you to perform your duty which you've never performed. I have a judgment that says you still owe me that duty because you couldn't lawfully hold the deceased. I have a judgment that says you've never performed that duty. I don't want that mandatory order maintained because my household has changed, but I want another mandatory order now in support of my assertion
They can do that.
you still owe me the duty.
Is there an application before this court for an amendment to be made to the remedy?
No, Lord, there isn't.
Right.
But there could be an application made by the respondent to the effect that she is still owed a duty and she wants that duty to be enforced by a court. Not necessarily, obviously, this court, but another court, the High Court, on an application for mandatory order. One of the authorities that we put forward was the Devon County Council case in this court, L, which concerned education and healthcare plans and the procedure for updating them. It's tab 2 of the authority, tab 3 of the authority.
Yes.
And one of the points made by Mr. Justice, sorry, I don't know why I'm finding this later, Lord Justice Peter Jackson, apologies to the Lordship, is that the ongoing relationship between the parties is a reason why the court might continue to hear the case. At paragraph 62, on page 30 of that bundle, he asks the question, what is an academic claim? And he explains that it's a claim where the outcome does not directly affect the rights and obligations of the party.
Yes.
The reasons I've advanced, we say, both in relation to the committal and in relation to the ongoing assertion of duty, this claim does continue to affect the rights and obligations of the party.
Directly?
Yes, because there is an asserted duty owed to the respondent by the local authority to provide her with accommodation. And there is an asserted right to a remedy by the respondent against the local authority for breach of a court order. And neither of those, my Lord referred to the letter of the 16th of January, which is of course an important letter because it does say that they're not seeking to uphold the mandatory order. But what that letter doesn't say is, and we're going to discontinue the committal proceedings, and we no longer require a duty under the Housing Act to be performed to us. But coming back to the point I referred to this case
Yes.
to make, paragraph 65, whether a claim is academic will, as is said above, depend on the particular circumstances. One reason why the present case is difficult to categorise is because the relationship between the parties is ongoing. The process of review and reassessment is an iterative one. Children are likely to need EHC plans throughout their education. There's at least a real likelihood that the issue that arose this year will arise for one or more of the claimants in future years. In that sense, that Mrs. Justice Edu considered the issues remain live between the parties. All events, the outcome is of potential future significance, as opposed to being a dispute that is now, so far as they are concerned, in the past, also of significance for the respondent and the educational authority. In a case where there is real doubt about whether a claim is academic, that will no doubt be one of the factors that the court will take into account in deciding whether to hear it. In the present case, the judge would certainly have done well to have taken the course followed by Mr. Justice Silver in Zulai, where he found the claim academic but went on to resolve the outstanding issues in case he was wrong, and so that he could deal with the question of cost. My Lord.
I'm afraid I don't understand this. Is the Court of Appeals there saying this was academic, but the court either could or should, in its discretion, have heard it anyway because of possible future impact? Or is it saying that it wasn't academic and therefore the discretion to refuse to hear it didn't arise?
The leading judgment given by Lady Justice Elizabeth Lang concludes that the issue was academic, but that the judge below had been wrong not to hear it anyway.
Now, how does this affect the Court of Appeal anyway? Because we're dealing with the Salem kind of situation. But I haven't read the facts of this, so you'll have to help me. But this seems to be dealing with a situation where the Court of First Instance was faced with an argument that something had become academic.
This was a case in which permission was given at a time when the judge hearing the permission application thought that the issues were sufficiently live to grant permission to allow the claim to continue.
Right.
At the final hearing, the judge took the view it was all academic and he should refuse to deal with it.
Right.
There was an appeal from that. This court held that the judge had approached the matter in the wrong way, and although academic,
Right.
he should have resolved the issue.
Right, fine. And does this court, does the judgment, or any of the judgments in L, address authorities like Salem and Dolan and so on? Because those are to do with what the Court of Appeal should do, where the case wasn't academic at first instance, but has become academic, arguably, on the facts by the time it reaches an appellate court.
My Lord, if I can take you to the judgment of Lady Justice Elizabeth Lang.
Yes.
She mentions at paragraph 28 that the judge had referred to a number of authorities, and then at 29 on page 25 of the bundle,
Yes.
she refers to the judge's citation from the Chishangu case, referring to the speech of Lord Slynn in Salem, and sets out that famous passage, and then continues to set out in detail, which I don't think I need to take my Lord to, the views that the judge expressed. Right. Picking up at paragraph 33, that the judge took the view that Salem concerned the jurisdiction of the House of Lords, and it was questionable whether a court of first instance had jurisdiction to continue. Yeah. And then related onwards to other cases where the courts had not heard matters that it had felt were academic.
Yeah.
The submissions, again, I don't think are likely to be of much assistance here. But at paragraph 48, Lady Justice Elizabeth Lang sets out begins to set out her views, and at 49 she identifies the first issue,
Yes.
whether the claims were academic. And she says she doesn't consider it necessary to reach a final view on the issue.
Right.
She will assume that they were academic, notwithstanding the view of Mrs. Justice Eady to the contrary, which is worthy of respect. So her judgment proceeds on the basis that the claims were academic. And then she talks at paragraph 50 about the flexibility of the judicial review procedure, but I accept in substance that may be more relevant to a case where the first instance court has made a decision rather than what this court should do. So I'm not going to take my lord to that.
Right.
But at paragraph 51 she says, on the assumption that the claims were academic, should the judge have refused to decide them, and holds that the court had a discretion
Right.
to do so. And then at paragraph 52 she considers the factors in favour, which largely essentially relied on the fact that the general issues were of public interest and that the parties were ready to argue them.
Yes.
And then at 53, was there anything that compelled the judge not to decide the issue? And she criticises the reasons he gave as being largely circular. So, to the extent that she then concluded...
Sorry, what's the proposition you're getting?
Well,
I'm sorry to be behind.
I'm not really seeking to get a proposition from this. My Lord Justice Singh asked me how this court had approached the case, and I was simply trying to...
Yes, but it begs the question, why is it relevant in the first place?
Well, because...
if I read on to the next paragraph, you can see what the fundamental difficulties were with the High Court judge's decision.
Yes, my Lord.
A complete confusion.
The only reason I took you to this was because I thought that it might be useful to see the comments of Lord Justice Peter Jackson,
Oh, I see.
to the extent that where a claim is academic or may be academic, one factor that the court should consider is the ongoing relationship between the parties.
Right.
And we submit that is not identical, but a similar consideration that arises.
All right. Can we just pause there for a moment to see? I don't want to stop your citation of
No,
this.
that was really good.
All right. Let me just see how this fits into the analytical framework. Well, where we seem to have got is that what you've shown us is a case where it wasn't about the question, is a case academic or not? It was about, assuming that it was academic, the discretion of the court, nevertheless, to consider it. And we know that there is a residual discretion in this court. Right? Salem has told us that, and this court has sometimes exercised that discretion in cases like Dolan, which was the pandemic regulations case. Right. So what I'd like to know from you is it your submission that we are in the territory of where you accept the case as academic, but invite us to exercise our discretion to hear the substantive appeal? Or is it your submission that we're not in the territory of this being academic at all? In which case, there's no discretion. We've got to hear. You bring an appeal, we've got to hear it.
My Lord, my primary submission is that this case is not academic.
Right.
And I've broadly outlined the reasons for that, though I'm happy to expand on those to the extent that it helps to do so. But my fallback position is that even if it's technically, there are strong public interest reasons why the court should nonetheless make an appeal. One of which is that although this appeal does not simply or solely raise issues of statutory construction that would be in the public interest here. First, it does raise questions of statutory construction, we say would be in the public interest here, which are likely to arise on multiple occasions, and which are an important aspect of the local authority's housing duties. But also, the grounds which do not raise questions of construction do raise questions, not of the detailed facts of this case, but of the general approach which a judicial review court hearing an application for a mandatory order in a homelessness context should adopt. And they're fairly straightforward legal propositions or legal grounds of appeal. Namely, should the court entertain such arguments at all? And if it should it approach those arguments by reference to public law principles, requiring the claimant to show that the local authority was not entitled as a matter of law to make those decisions? Or was the judge entitled to approach it on the basis of saying, well, I've looked at the evidence and this is what I think of it, which we've described as a merits approach? Now, in my submission, it is largely unimportant what the merits were, what the judge made of them, and what view he came to on the facts. We are not inviting this court to go into a long trawl over the factual circumstances and decide whether he was right or wrong to reach those conclusions. The grounds of appeal we raise are at a higher level question, if you like. Should he have gone down that road at all? Whether because he shouldn't have entertained the issue, he should have left it for the alternative remedy to be resolved. Or, if he should have gone down it, should he have gone down the road of looking at the evidence and making his own decision? Or should he simply have conducted a judicial review process, conventional judicial review process? Now, we say that falls into the Salem exception, because it's not a question that turns on the detailed facts of the case. These are important points of legal principle rather than detailed points of factual issues.
Right.
So our submission is, effectively, firstly, that this is not an appeal that is academic at all. I think probably I have exhausted my ability to put that point in different ways. But I will take, my Lord, to the letter of the 6th of January.
Yes.
That would be helpful.
Well, you must take whatever course you think right.
But secondly, if I'm wrong about that, there are good public interest reasons.
Well, you've made that point. You understand that.
I'm great.
So, do you want us to look at the letter?
My Lord, the letter is at section G of the supplementary bundle. It's at page G1.
Yes. Towards the end.
Yes, ma'am.
Yes, thank you. Right. Yes.
My Lord, what we say is important about this is that what the letter says in the the first paragraph refers to the changes to personal circumstances affecting the factual nature. The second paragraph refers to the fact that the client no longer seeks accommodation where she and her brother can live together.
Yes.
And therefore, she is not instructed to lift the stay and are agreeable to the order being discharged. One of the points made at the permission hearing in front of Lord Justice Lewis was that it's not for the parties to agree whether or not court orders be discharged. It's a matter for the court. But that's by the by in some respect.
Well, that's true, but we frequently get consent orders placed before this court. Of course, it's a matter for us to make a judicial determination, but it does happen.
And it's on that limited basis, we say, that it's put forward that the claim has become academic.
Yeah.
But what I say about that...
Did you respond to this letter?
Well, what happened was Lord Justice Lewis required us to put in a position statement for
Right.
the hearing, which is the next document.
Yeah, I've seen that.
So I don't think there was a.
Wait, hang on. I may have misread this. The
Sorry,
position.
this
Sorry.
isn't this document.
No, I thought it was not. Okay.
But we did put in a letter to the court
Have we got that somewhere?
responding to it. For some reason, I don't think we do.
Oh, well, that may be an important document. I don't know if it can
I
be.
can certainly provide it.
Would it be possible for somebody
Yes.
to email it, possibly to judges, clerks
Yes.
now, immediately?
Yes.
Is that possible? I don't know if your junior can do
See
that
if I can do
while
that.
you're on your feet. Or,
I don't want to encourage the court to think that I know how to do that while I'm on my feet at the same time. But I will.
well, don't take time over that now.
I'll get a copy of
You've
it.
got submissions to make, and we've got limited time to consider this.
What I would say is that that response made essentially the same points that I've been making
Yeah.
this morning, namely that the I think from memory in particular, focusing on the committal proceedings. I think my learned junior has found a copy. What's the date? 22nd of January, and can email that to my lord's clerks and to my learned friend. Now, I think that's happening now. So the only point I wanted to make about that letter is that it is a limited assertion of a basis for the claim being academic, which does not actually go behind anything that either party has said to this court, namely that the committal was ongoing and the duty is asserted to be continuing.
Does anyone ever make the point? I certainly didn't find it in your skeleton. Forgive me if I've missed it. That although the mandatory order would be discharged on their concession, there's still a declaration, which is, and the declaration is the subject of an appeal. Is that your? That's now formed a fundamental part of your oral submissions before us. And it may be right. I'm not criticising. I just wanted to know if anyone's ever made that point before.
I thought we had made that point, my lord.
Well, forgive me if I've missed it. This is why it would have been helpful to see the letter of the 22nd of January.
Yes,
I
I'm
didn't-
not
I didn't-
sure that point was made in that letter.
Right, well, if it wasn't made then we're not missing anything by not seeing it. No, was it made in your skeleton argument? I didn't see it, but I may have missed it. Seems to me quite an important point, because actually, as per Lake and Lake, your fundamental submission is that this court has currently got an appeal before it against, all right, not a coercive order, but a formal binding declaration of the High Court, which, unless it's overturned by this court, is going to stand.
My lord, yes. That is.
And do remind yourself of what you said in your skeleton argument. You dealt with the academic issue at pages 19 and 20, at paragraph 72 to 77. And forgive me if I've missed it, but I just did not see that point, that there's a declaration against you, which needs to be set aside. Anyway, it doesn't matter. That is your submission before us now.
Yes.
Yeah, and it's a good submission or it's a bad submission, and we'll decide that. But that's I read it. That's really the thrust of your argument to us as to why this case is not academic.
Well, it's certainly an important part.
Right. Okay. Is there anything else you want to say?
I think not at this stage.
Can I just ask my lords if there are any questions? Thank you, Mr.
Thank you.
Yes, Mr. Darby.
My lord, firstly, the first submission I was going to make, well, there are two orders in this case. There is the order of 21st of November, which is at page A208, electronic page 257, which makes the declaration that the defendant has been and remains in breach of the main housing duty.
Yes.
And the letter written by my solicitors related solely to a mandatory order. My learned friend is right to say it was quite good, but did not relate to this declaration, which is why it's the respondent's case that the main housing duty continues to be owed.
So why was your solicitor saying in the letter of the 16th of January that their appeal has now become academic?
Well, it was being put to the authority that the appeal was academic because we're no longer seeking the mandatory relief order. Perhaps it would be more accurate to say that the appeal against the mandatory order is academic.
Right. And do you accept that analytically there are in truth two appeals before this court, one against a mandatory order and the other against a declaration?
My Lord, there are, and I was going to highlight another difficulty that the appellant faces, which is that that part of the declaration and that part of the brief was challenged in ground 8 off the grounds of appeal, which is at A81, electronic page numbering 130.
Sorry, what?
So these are the appellant's grounds of appeal in this court.
Where are you looking at now?
At A81, the core bundle A81.
Ground 8, grounds of appeal. Yeah, what's this about?
So that's the judge erred in law in holding that the appellant was in breach of its obligations under section 1932. So that's the declaration. And the interim order of His Honour Judge Williams of the 25th of June, which is effectively is my learned friend's committal point, which I will address separately. But the appellant was refused permission on ground 8.
By both the judge below and Lord Justice Lewis?
Yes.
Right.
And that order is at A15, which is electronic page numbering at 64. And you will see A16, the appellant is refused permission to appeal on grounds 7 and 8.
Yes, I've read Lord Justice Lewis's judgment, or transcript of it, but thank you for reminding me of the order. Right.
So what we were inviting to do, and perhaps, my Lord, it could have been expressed differently. What we were saying to the local authority in January was the respondent no longer needs to be accommodated with her brother. And therefore, that part of the order is not, that part of the claim has become academic. What we weren't saying, and my learned friend is right to say this, what we weren't saying is that there is no duty owed.
No.
And that, but what we're saying is what is suitable for her, that has changed.
Yes, but what's your submission to this court today, given what you've just shown us?
Yeah.
That the permission on ground 8 was refused. What do you say we should now do? Is this is this academic? And B, even if it is, should we exercise our discretion to hear it?
Well, my Lord, we don't say it's academic.
Right.
For this reason, that we say that the respondent continues to be owed the main housing duty, and that duty did not cease by operation of section 1936D.
So 193
6,
6.
little d.
So I misheard.
And it's of some importance to the respondent because she's now back on the merry-go-round of the authority making inquiries and sort of starting its decision-making from scratch. I was looking at it from the other end. If she is right, she already has the benefit of the main housing duty.
I see.
The difficulties for my learned friend in my submission, when he comes to make his submissions, is that he was refused permission on ground 8. So his committal, for example, his committal point, I mean, my Lord, you may not need me to address that in the light of...
No, I do need you to address it. I want to know what your submission is. You say it's difficult, but you're essentially agreeing with him that we should hear this appeal. Is that right?
Yes, my Lord. I'm certainly not saying that you shouldn't hear the appeal.
Right.
But
despite the fact that, as you're reminding us, the ground which related to the points that have been advanced principally before us today was refused permission.
That's right. Well, so when I say hear the appeal, what I'm inviting, if the court is with me on that, is then if it transpires upon the court's reflection that the real challenge is effectively a dressed up challenge which was within ground 8, which permission has been refused, then the appeal must fail.
Hang on, there are 6 grounds on which permission has been granted.
But there are 6, well, yes, my lord, and that's why, yes,
But I'm sorry, Mr. Nami, it's my fault. I'm not understanding what you're asking us to do on this preliminary issue. Yeah. Is it your submission that because permission to appeal was refused on ground 8, that there is in substance nothing left which is not academic, and therefore we should decide the preliminary issue and not consider grounds 1 to 6? Or are you saying that we should consider grounds 1 to 6 but dismiss them on their merits? Because if that's your submission, then we're going to have to start the substantive appeal soon.
Well, my lord, my primary submission has to be that the ground 8 referred to relief. That was a challenge to the relief ordered by the court. Right. And they haven't got permission to appeal the relief. Right. So the other grounds, if there's no permission to appeal relief, then the other grounds are technically academic in that sense, in that it would make no difference to the relief that has been obtained.
Okay. Well, I'm going to summarise that back to you,
Yeah.
okay, at least on a contingent basis.
Yeah.
What that sounds like to me is that actually you are submitting on the preliminary issue that the appeal by the local authority has become academic. Let's assume that for the moment, okay? What I would like to know is, do you have any submissions you wish to make to us on that contingent basis that the appeal has become academic? Is there anything you want to draw to our attention as to why we should nevertheless exercise our discretion to consider the substantive appeal?
My lord, may I just
Of course.
turn my back for a moment? My lord, there would be nothing further that I would say.
But what we want to make sure, obviously, is to be fair to both sides. We want to make sure that we don't inadvertently do something or say something that will prejudice the respondent. And that's why I'm giving you this opportunity.
Well, what we say, our unwavering case throughout has been that the respondent is owed the main housing duty, and that she continues to be owed it, and by not complying with it, the local authority is in breach of that duty. That appears to be dealt with in ground 8, for which permission was refused. So if there were to be any, if the local, and that's why we've carried on engaging with the appeal, because we do not want the respondent to be in a worse position than she would have been with the benefit of His Honour Judge Rawlings' judgment. But she has a positive finding, a declaration that she's owed the main housing duty. My Lord, do you wish to, may I just quickly address you on the contempt?
Please do.
Yes. So, my Lord, firstly, committal is a completely different set of proceedings to an appeal before this court. It has a different standard of proof.
What's the standard of proof?
At contempt, it would be beyond reasonable doubt. Right. It would be open for the local authority in any contempt proceedings to say they honestly believe that they were complying with the order. But again, the authority does run up against the problem of Ground 8, where it sought permission to appeal the finding that it was in breach of the interim order of Your Honour Judge Williams, and they've been refused permission on that. So hearing this appeal really doesn't take the matter much further as far as the committal application is concerned. In my submission, the committal application is something of a red herring in this appeal.
You've heard, I think, two members of the court make the point about the committal proceedings, that they're again, I want to be enlightened, so please help me, correct me if this is wrong. But my understanding, and I think my Lord's as well, is that the committal proceedings were launched soon after the interim order had been, because, as is typically the case, the main, perhaps the only purpose of committal proceedings is to try to secure compliance with the court's order, and therefore is very much rooted in the circumstances which were then in existence. Am I saying anything which you disagree with?
My Lord, no. The object of the application for committal was to seek to secure suitable accommodation for the...
But there was, sorry.
No, please.
There was something that happened that provoked, a day later, there was something that council, I'm trying to remember what it was, can you help? There was obviously an offer of accommodation which you thought clearly was not suitable at that stage.
Yes.
My Lord, yes, that's because they made an offer of accommodation that we said they'd already found to be unsuitable.
Yes, that's what I thought it was. I was just trying to remember the address.
22 Langdon Road.
Yes, where the story on the starts.
Yes.
Yes.
Then why are you pursuing contempt?
What, my Lord, at the moment, the court has stayed the contempt proceedings.
Yes, but the question is, what purpose does it serve?
Well, what the judge said when he stayed the proceedings was he said that he thought there was a public interest in court orders being obeyed. And that's why at that stage he stayed the contempt proceedings rather than making any other order.
But you're the applicant.
I'm the applicant.
So you can say, I withdraw the contempt proceeding.
Yes, Your Honour, I can.
For what you've just told us, presumably you will do that.
Well, my Lord, I would have to take instructions and consider that. I don't have instructions today to withdraw the contempt proceedings. I see the force of what my Lordship says. What your Lordship
but
says.
it seems to me that very substantially we're being told by the appellant that we have to hear this appeal because of the contempt proceedings. But it seems to me that the contempt proceedings, even on what you, the applicant, is saying, no longer serve any purpose either. Because you accept that they're only there to secure you suitable accommodation, which at the moment is not a live issue.
Yes.
So it just seems to be, we just seem to be playing games here.
Well, may I just turn my back for one moment?
Yes.
My Lord, I'm grateful for having that opportunity, and I apologise for turning my back. My Lord, you're right to observe, and your Lordship is right to observe, that the contempt applications were issued at a time when accommodation was urgently required. They're leaving aside the issue of costs about the contempt application. If the only matter standing in the way of if your Lordship's find that the only reason for the appeal proceeding would be because of the contempt application, then the application would not be proceeded with. So that should not, so I have to put that rather inadequately. The contempt proceedings should not be a reason for the court proceeding with the appeal, because if the court decided to dismiss the appeal, I have instructions that the application of contempt would not be proceeded, subject to the issue.
Could that be put in writing if we do take that course? And I stress to everyone, we have no view about any of this. We're just listening to the arguments. But could that be put in writing?
Yes, my lord.
All right. Is there anything else that you want to say?
My lord, no.
No, just check if my lords have any more questions. Thank you, Mr. Nabby. Yes, do you want to reply?
Well, just briefly, if I may. But in my respectful submission, ground 8 is a red herring. My learned friend is wrongly characterised. He took, my lord, page A81. Ground 8 begins with a statement, perhaps reviewing it now, it might have been an unnecessary paragraph 26, which says the judge was wrong to hold we were in breach and we rely on grounds 1 to 7 above. But ground 8, the meat of it, at 27 and 28, is about a question of the way the judge exercised his discretion. If we were in breach, should he nonetheless have said, well, they've done their best and therefore relief should be refused on a discretionary basis because the court won't order the parties to do the impossible. That's what ground 8 argued, and that's what we were refused permission on. Lord Justice Lewis saying the judge identified the factors he took into account in not taking that course and he was entitled to do that. But what we say is that the challenge to the ruling, the declaration and the making of the mandatory order, is throughout the 6 grounds for which we have permission. Because that was the order, that in total was the order that he made, and we say he was wrong to have made all of it. And just finally, well, it may not be necessary to me to reply on this, because if, in the light of my learned friend's concession as to the committal proceedings, it may be that those proceedings are of less weight to my lords than they were when I stood up. I don't know if they have any weight then, but what I would say is that the standard of proof being different is not relevant, because what we're talking about is a decision by a judge as to a legal position, not a question of fact in the way that would be amenable to a different standard of proof. But those are the only points I have in reply.
If I stress that we have no concluded view as to any of this. We'll have to rise to consider what we're going to do in a moment. But can I just ask you this? If we were to take the view that the appeal has become academic vis-à-vis the mandatory order, but that we can see merit in your submissions, that we still have to consider the substantive arguments because there is a binding declaration in place and you want to have that set aside. Are there any submissions you want to make to us as to whether we should take that, if you like, halfway position? So we wouldn't necessarily rule you out completely, but we would make it clear that it was only in respect of the declaration that we would consider.
Well, my lord, I would invite the court to take that course if it takes the view that the issue relating to the mandatory order is academic. I would submit that the declaration is still a matter that affects the ongoing rights and obligations of the party, and that the court should allow us to bring the appeal in relation to challenging that declaration, which is not the subject of any concession by my learned friend.
Just finally on that topic, can I ask you, is there anywhere in the grounds of appeal or any other document you'd like to show us where there is a challenge explicitly against the making of that declaration?
I think the best I can do is, for example, on page A76 of ground 1, where we say that the judge erred in law in deciding to determine the lawfulness of the defendant's discharge of its duty. And we use a similar formulation.
Well, I'm sorry. I read ground one to be the alternative remedies.
No, ground one is ground.
This is one of the problems, if I may say so, the grounds which are actually not formulated in the way that the court has frequently said they need to be formulated, which is in numbered paragraphs where it's clearly labelled what the ground is. I find this in numerous appeals before this court and before the High Court, that what are said to be grounds are actually arguments. And one then, over a number of paragraphs, and one has to delve into them to see what the ground is. So what on your submission is ground one?
Ground one is the argument that the court shouldn't have entertained.
Yes, but why?
Because it should have been left to the alternative remedy.
Exactly.
Exactly.
That's what I just said.
Yes, I know.
So why are you showing us this in answer to my question of where we find a challenge to the declaration?
Well, in the appellant's notice,
Right. A1. Yeah.
in section 5,
Yep.
please set out the order you wish to appeal against.
Yeah. Page
Page A4.
A4. Yeah.
It says, the order of the 21st of November, it is declared that.
Yeah. That's what I was looking for.
Sorry, I misunderstood what my lord was asking me. I do apologise.
Yeah. So your submission, as I understand, really boils down to this: that even if one puts out of one's mind the mandatory order, that there is a valid appeal before this court because you have appealed against the declaration made on the 21st of November, and there is no concession that should be discharged, and therefore the court should now consider the substantive appeal, at least in respect to the declaration. Any other questions?
Only just to say, we now have your thanks, your written statement on the current status of the appeal. And it does seem that was addressed almost entirely to the contempt proceedings continuing.
I think I have to accept at that time that that's what the primary focus was. And it was only a few days after the letter had been received. And I think the view was taken, if I may try and recall, that was, in a sense, enough of an answer to the question of whether the proceedings were academic. Obviously, since that point, Lord Justice Lewis decided not to express a view one way or the other.
Yes, but he made it clear that it was a matter that the parties had to address.
Yes, and then when we revised our skeleton argument in accordance with his order, requiring us to deal with the question of whether the at that point that we considered it in more detail.
Yeah. Anything else? Right. What we will now do is to rise to consider the next step.
What rise the table? Court rise the table.
Right, Mr. Manning, thank you both for your submissions this morning. We're not going to make a definitive ruling one way or the other on the preliminary issue at this stage. We will proceed to consider the substantive appeal on the contingent basis that it has to be, and in due course in our judgments we will address both the preliminary issue, the academic point, as well as the substantive issues if they have to be determined. But so what you should now do is proceed with your grounds of appeal on which you've been given permission. And I know that you will bear in mind that the court must finish this appeal today.
My Lord, I'm grateful for that decision. We have, as you know, raised 6 grounds, but as I've attempted to explain, some of them raise the same issues. So, in effect, we're dealing with 4 issues, one of which is the availability of alternative remedies, one of which is the approach the court should take, and then 2 questions of construction, one in relation to Section 193 of the Housing Act 1996 and one in relation to a letter. What I've described in my submissions made in relation to the preliminary point as the suitability grounds 4, 5 and 6, essentially are to the effect that the court should not have entertained the dispute about the suitability of accommodation provided in the context of an application for a mandatory order. My Lord, we are content so far as the
maybe I'm not following, but I thought we were looking at this in the context of an appeal against the declaration.
yes.
You just referred to the mandatory order. Maybe I apologise if I'm barking up the wrong tree, but aren't we looking at the grounds of appeal through the lens of an attack on the declaration?
My Lord, yes. I'm sorry.
Sorry.
It was a
For a moment,
slip.
I thought
No. It was a slip on my part.
Okay.
What I was saying was these were proceedings in which a mandatory order was being sought, and that is still the context that existed at the time the judge entertained the case. But yes, declaration. It is still, I suppose, the important issue from my perspective is that these were judicial review proceedings. And that is important because of the nature of judicial review proceedings as a remedy of last resort. And therefore the availability of an alternative remedy is relevant to whether the judge in judicial review proceedings should have entertained the argument on that basis. Well, Lord, can I begin by going to the legislation? Tab 1 of the authorities bundle. Given the time, I'm not going to, unless it would assist, go through part 7 of the Act in any great detail, but I'm going to focus on the particular sections that are of particular importance to this case. If I could start at page 7 of tab 1. Section 175, 1, 2 and 3 set out the statutory definition of homelessness. And subsection 1, and I don't think this is going to be remotely controversial between the parties, applies where a person has no accommodation, which he's entitled to occupy by virtue of one of the three statuses that is referred to in paragraphs A, B and C. Subsection 2 applies where a person does have accommodation but either can't get into it or it's a movable structure and has nowhere to put it. More importantly, perhaps for this situation, subsection 3, person shall not be treated as having accommodation unless it's accommodation which it would be reasonable for him to continue to occupy. And I'll come back to the relevance of that, if I may, in due course. My Lord, section 184 on page 13 is the duty on the local authorities. Subsection 1, if they have reason to believe that an applicant may be homeless or threatened with homelessness, to make such inquiries as are necessary to satisfy themselves whether he is eligible for assistance, and if so, whether any duty, and if so, what duty, is owed to him under the following provisions of this part. They may also make inquiries about whether he has a local connection, but we don't need to worry about local connection in this case. And then 3, on completing their inquiries, they shall notify the applicant of their decision, and insofar as any issue is decided against his interest, inform him of the reasons for their decision. My Lord, the next page that I would like to refer to the court is page 17, and this is section 193 of the Act, which has been heavily amended over the years. But it applies, subsection 1, where the authority are satisfied that an applicant is homeless and eligible for assistance, are not satisfied that the applicant became homeless intentionally, are also satisfied that he has a priority need. C is not relevant to this case. It arises as a result of an interim accommodation duty under section 189B2 having come to an end. And the way the Act is now structured is that on an application, if the authority thinks that an applicant might be homeless, eligible for assistance and have a priority need, they have to provide essentially 56 days of accommodation. When that comes to an end, that now triggers a section 193 duty if the other criteria in subsection 1 are met, but I don't think we need to worry about that.
Good.
And subsection 3 is important. The authority are subject to the duty under this section until it ceases by virtue of any of the following provisions of this section. So it can't simply come to an end unless there is something in the section which brings it to. Subsection 5, the local housing authority shall cease to be subject to the duty under this section if the applicant having been... Now, there are two... I must apologise to the court because there are two versions of subsection 5 which are set out here. The first one, as I understand it, only applies now in Wales. But in England, the second one, with A, B and C, is the relevant one. If we should have taken the provision from Westlaw, which is clearer, but I can hand up.
Could that be checked? Because this, on page 17, this part 7 is headed England, and at the top of page 18, England appears as well. But
My Lord,
what are you going to hand up now?
I was going to hand up the version of this section from Westlaw rather than legislation.gov.uk.
Okay, let's have it.
And I was also, oh yeah. Have you got all the pages? Can you check the pages? Just hand it to me. With the West. We have another.
Thank you.
So this is what we should look at.
Yes, please, my lord. I'm. My learned friend will correct me if I'm wrong, but my understanding this is the accurate version. I'm not entirely sure why legislation.gov has.
Don't worry, just show us what you need to show us.
Subsection 5, my lord. The local authority shall cease to be subject to the duty under this section if the applicant, having been informed by the authority of the possible consequence of refusal or acceptance and of the right to request a review of the suitability of the accommodation, refuses an offer of accommodation which the authority are satisfied is suitable, that the offer is not an offer of accommodation under Part 6 or a private rented sector offer, and the authority notify the applicant that they regard themselves as ceasing to be subject to the duty under this section. So that's one way it can come to an end.
Yes.
Subsection 6, which is the one that applies in our case, the local authority shall cease to be subject to the duty under this section if the applicant ceases to be eligible for assistance, becomes homeless intentionally from the accommodation made available for his occupation, accepts an offer of accommodation under Part 6, allocation of housing, that's long-term housing, or D, otherwise voluntarily ceases to occupy as his only or principal home the accommodation made available for his occupation.
Can I just ask, is there a requirement to notify, as we saw at the end of subsection 5?
No, my lord.
Okay. I mean, there was a notification because in this D case,
Yeah.
in some of these examples, you wouldn't need to notify, but there's no statutory requirement to notify.
No, and my lord, in the Banno case, which we have in the bundle,
Yeah.
this court made that point about the duty coming to an end under subsection 7, drawing a distinction between subsection 5.
And 7. Okay. Thank you.
7 is a refusal of a final offer of accommodation, in other words, long-term accommodation under Part 6 of the Act. And we say that subsection 6 is the same in substance as subsection 7, and I'll come to that later if I may. And then, if I can move to section 202, which is on page 20. An applicant has the right to request a review of, and I rely on B, any decision of a local housing authority as to what duty, if any, is owed to him under sections 189B to 193C and 195, duties found to be homeless or threatened homelessness. We're within that range of sections in section 193. And then F, G and H, any decision on page 21 of a local housing authority as to the suitability of accommodation offered him in discharge of their duty under any of the provisions mentioned in paragraph B, and then any other suitability decisions in G and H that might arise that we don't need to worry about. But it clearly provides that suitability is a matter that is subject to the right to a review.
So we're dealing with F then, is that right?
We're dealing with F.
Thank you.
in subsection 3, there is a 21-day period beginning of the day on which he's notified of the decision, or such longer period as the authority may allow. And 4 is a requirement to conduct a review if a request is duly made. The procedure on review is the subject of section 203 on page 22. We don't need to go into it in a huge amount of detail, but provision can be made by regulations made by the Secretary of State, and he did so in relation to this section. And we see the sorts of things that the regulations can be about the level of seniority of the person who makes the review decision, the circumstances in which an oral hearing can be required, and representation at such a hearing. And 3, the authority concerned shall notify the applicant of its decision on review. And 4, if the decision is adverse on any issue, there's a reasons requirement. And 5 is the requirement to tell him that he has a right to appeal to the county court on a point of law, and the period within which such an appeal may be made. Unless 4 and 5 are complied with, notice that the decision is not treated as having been given, and there are provisions for a time period for the review to be carried out. So it's a comprehensive provision for a review procedure, including potentially oral hearings, representation, and decisions with reason. Section 204 is the right of appeal to the county court on a point of law. And that arises in 2 situations by subsection 1. Firstly, if the decision on review does not satisfy the applicant. And secondly, if the decision on the review is not notified to the applicant within the prescribed time under section 203. So an applicant who doesn't get a review decision can still go to the county court and challenge the original decision. There's a time limit of 21 days, but the court has a power under subsection 2A to extend time, certain circumstances. And at 3, the court has a power not merely to confirm or quash the decision, but also to vary it. And there is authority on the circumstances in which the court should vary a decision. I don't want to go into it because it's not necessary, but it is important to note that the court has that additional power. Okay. That is, in my respectful submission, all I need to trouble my lords with in relation to the statutory scheme, right. For the moment. So when we come to consider the grounds of appeal, in relation to ground 1, whether the duty had ceased by virtue of subsection 6D of section 193, we submit respectfully that the judge should have held that that was a decision under section 202(1)(b as to what, if any, duty was owed under section 193. The authority had decided that no duty was owed because the duty had ceased. When we come to ground 5, the question of whether or not the properties were suitable, we say the judge should have said that falls within section 202(1)(f), the decision as to the suitability of the accommodation offered under one of the provisions mentioned in paragraph B, namely section.
Sorry, namely what?
Section 193 is one of the provisions referred to in subsection 202(1)(b), and therefore 202(1)(f) applies to it.
Yes.
So we say this was clearly a situation in which there was a right Parliament had conferred to a statutory review and a statutory appeal. We say that the courts have held on more than one occasion that in those circumstances, the Judicial Review Court should only in exceptional circumstances entertain a judicial review on a ground where there is a right of review and appeal. And I wonder if I can go, in the time, if I can go straight to tab 16 of the authorities bundle, which is the Banno and Waltham Forest case, in which this court made its decision last year.
Sorry, which tab is this?
Tab 16, my
Thank
lord.
you very much.
Is this the case where judgment is awaited in the Supreme Court?
It is, my lord. Yeah.
On this point?
Not that I'm aware of.
Okay.
I think it may be on the need for notification point, however.
Thank you.
My lord Ray.
All right. Okay.
But-
So where are we going?
So if I can simply go to the head note, this was, just to note, this was a case involving refusal of an offer under section 1937AA, which is one of the final offer provisions. So it's not a section 1936 case. The argument was that the authority continued to owe a duty. This is at letter E on page 285. Continued to owe a duty. The duty hadn't come to an end because, one, the authority had not made a decision that the duty came to an end, such a decision being necessary to bring the duty to an end, and two, its private rented sector offer had not informed the claimant in writing of other matters mentioned in section 1937AB. I don't need to take the court to the first holding, simply say that is the point at which this court held that there was no need for notification. For the second holding, that an applicant for housing assistance would have a right under section 202 of the 1996 Act to request a review of the local authority's decision to make a private rented sector offer, since such a decision was a decision as to what duty, if any, was owed within the meaning of section 2021B. Being a decision prospectively to discharge the local authority's housing duty under section 1932 by making an offer, that moreover an applicant would have a right to request a review of a local authority's decision that its duty had ceased following the refusal of the offer, since such a decision was likewise a decision as to what duty, if any, was owed within the meaning of section 2021B, even if it was only a confirmatory, that therefore the claimant in the present case could have requested a section 202 review after the claimant had refused that offer, that its duty to the claimant had ended, and that since the claimant could in either review have taken the point that the local housing authority's duty had not ended because it had not informed the claimant in writing of the matters mentioned in section 1937AB, the claimant had an alternative remedy other than judicial review available to her, and that accordingly it would not be appropriate to allow the claimant to claim judicial review, there being no exceptional circumstances which would warrant permitting her to do so when she had the alternative remedy available to her. And Lord Justice Newey, at paragraph, I think I can pick it up at paragraph 54 on page 303, at paragraph 54, he makes the point as to what the relevant sections that he is dealing with hold. And
Sorry, that's paragraph.
54, my lord.
Thank you, sorry.
And he contrasts the wording of the section 1937 provisions with those in 1935, which do require notification, and holds that on the face of it, the duty ceases as soon as the refusal takes place. It doesn't require a further decision. But he starts at paragraph 59. Even supposing on page 304 that that is wrong, Mrs. Barno will, as it seems to me, have been entitled to request a review. And he explains why that should be. And he then decides at paragraph 69 and 70, page 306, 307, it's plain that the court has a discretion where a person claiming judicial review has failed to take advantage of an alternative remedy. However, Lord Justice Sales, as he then was explained in Glencore, if Parliament has made it clear by its legislation that a particular sort of procedure or remedy is in its view appropriate to deal with a standard case, the court should be slow to conclude in its discretion that the public interest is so pressing that it ought to intervene to exercise its judicial review function, along with or instead of that statutory procedure. In the present case, it was clearly Parliament's intention in enacting Section 202 of the 1996 Act that such challenges to decisions as identified in Section 2021 should be pursued by way of review, and if necessary, appealed to the County Court, not through judicial review. It's noteworthy that Parliament thought it appropriate to require a request for review of a decision to be made within 21 days after notification, unless the local authority allowed a longer period. In my view, it's not appropriate to allow Mrs. Bannett to claim judicial review. I do not think there are pressing or exceptional circumstances which would warrant permitting her to pursue a claim for judicial review, notwithstanding that she had available to her but failed to invoke the procedure which was meant to apply in relation to decisions as to whether a duty was owed. In Nipperbagan, Lord Justice Old said, save in the most exceptional circumstances, the residual jurisdiction of the High Court should not be regarded as a backstop for the appellate jurisdiction of the County Court, where the applicant for housing assistance has failed to appeal a review decision within the 21 days time. I do not consider such exceptions to exist in the present case, and would therefore allow the appeal. Now, that is not the only instance of this court taking that view. We've also referred.
Just before we leave that case, the alternative remedy objection was raised by the authority in the High Court,
Yes.
at the permission stage. In the present case, was this point taken in the summary grounds of defence, or indeed in the detailed grounds?
No, because at that stage there was, well, certainly at the summary grounds of defence stage, the offer had been made, but there was no question of a challenge to that offer having been made.
No summary grounds were filed.
Sorry. So, was it cutting through this quickly?
Yes.
Was the point taken, the alternative remedies point taken in the detailed grounds of
I
resistance?
don't believe it was.
No. So when was the first time it was taken?
It was taken in the hearing.
Was it in the skeleton?
I can't remember.
It was in the skeleton. It was a one-line paragraph.
The way in which the fact developed.
But by that stage, permission had been granted.
Yes. Yes.
So the judge was right in his judicial instinct to take the view that, well, here we all are. Permission has been granted. All the evidence has been filed. All the arguments have been made in writing. So I'm not saying that you're wrong in your ground to appeal, but one can perhaps understand the judge's judicial instinct that one should get on with it.
My lord, yes, and it's very much in my submission with respect to the judge below. It was very much his approach. Well, we're all here, and I should deal with it. But in my submission, that's not the correct analysis.
But if I may respectfully say so, Mr. Manning, what you've shown us in the last 20 minutes is pretty trite law in public. The adequate alternative remedies principle, that there's discretion to be exercised only in exceptional circumstances, authorities, Claimant and many others, actually, many decades before that, like Swati, going back to the mid-80s. So why wasn't this point taken squarely, if not at the permission stage, then at least squarely before the judge?
Well, it was taken before the judge. It just wasn't. I'm not seeking to avoid responsibility, but I was not involved at the stage where the detailed grounds were pleaded. So I can't explain the fact that the point was not taken in that way. What the matter turned on, it seems, in the court below, was whether or not the authority had agreed that the accommodation at Holden Close was unsuitable, and that the accommodation at the hotel that had also been offered, the Ladbroke Hotel, was unsuitable. And that turned on the construction of a letter that had been written on the 4th of June, when the respondent had first raised the issue of suitability when she moved into the court. And I'm certainly proposing to come on to that. But what the local authority submitted and submit is that did not amount to an acceptance that the accommodation was unsuitable, and that there was therefore a dispute between the parties, which, unlike the other cases in which mandatory orders have been sought by the court, where the local authority had clearly said, we accept the accommodation is unsuitable, but we haven't got anywhere else to put it. So the court was proceeding on the basis of, well, what should we do about an agreed fact, an agreed condition of unsuitability. Here we had a dispute which the claimant had a perfectly adequate and indeed statutorily prescribed means of resolving, which would have given rise to a reasoned review decision by the authority, which could then have been challenged on the point of law. What we ended up with was a situation where in October of 2025, the judge was essentially saying, well, in June, I read this letter as saying X, but if it didn't mean that, then it could only have meant Y. And I take the view that this accommodation was never suitable. So the starting point...
Sorry, forgive me, if this had gone through the alternative procedure, review followed by an appeal to the county court, it's an appeal on the point of law.
Yes.
So in Edwards and Bairstow territory, the basis upon which the judge could intervene would have been very similar to judicial review.
Except for the fact, my lord, that at that stage there would have been a reasoned decision on review.
Yes, I see that, yes.
Which the court could have entertained
I do see that.
as a challenge, as a basis for it.
Could I ask one other question? I think you said that there would have been the opportunity to ask for a review compliant with the 21-day time limit.
Well,
and I didn't. If you are saying that, I didn't understand it.
Well, there was a letter in June where we say the authority was plainly making it clear that they intended to keep the respondents in the accommodation that they were saying was unsuitable.
That's June
2025. She was represented at that stage by experienced solicitors. There's no reason why they couldn't have sought a review of that decision at that point. The council also...
On the issue of suitability.
On the issue of suitability. The council also has a discretion to extend time, even if outside the 21-day period, which could have been sought. If the position were that the council's position on suitability only became clear at a later date, an extension of time could have been sought. Well, we don't accept. We say the letter itself is clear, but that's a matter that I'll come on to. My Lord, in answer to the point put to me by my Lord Justice Singh that Bano says nothing within right law. The reason why in my submission it's important is simply that it applies that reasoning to this statutory scheme. And
I see that. I don't want to go over the procedural archaeology, but all I'm suggesting is that if such an important and fundamental objection to the High Court hearing this on JR, one might have expected it to be raised, and raised at an early stage.
well,
To stop everyone wasting a lot of time and resources, including your resources, not just the court.
my Lord, I hear that criticism, as I'm sure those behind me do as well.
All right, now can you just help me with this? Where are we in the context of your overall structure of the grounds of appeal? Where are we?
So I have advanced the bulk of my submission on grounds 1 and 5,
Right.
which are mirror arguments, in the sense that ground 1 relates to the judge entertaining a decision that the duty had ceased. Ground 5 challenges his
Yes.
decision that the property was unsuitable.
Yeah, and if I were to express it in a nutshell, it is the adequate alternative remedies argument,
Yes.
right? We understand that argument. Is there anything further you need to say about it?
No, we've referred in the skeleton to the Ranahara Begum case,
Right.
which makes, we say, the same jurisdictional point. In the light of the time, I wasn't proposing to take my lord to that case, but
Good.
perhaps I could just ask your lordships to have in mind paragraphs 32, 33 and 47 of that decision,
And
which is at
47.
tab 6 of
Thank you.
your
We will certainly do
authority
that.
bundle.
Thank you.
My lord, in essence, that is all I can say about
Yep.
those grounds. It's a
Very,
fairly
very clear.
short point.
It is.
I was then going to come on to grounds 3 and 6, which again are mirror arguments. Ground 3 says if the judge was going to consider whether or not the duty had ceased and was going to consider suitability, then he needed to apply the principles of public law, and he didn't do that. That is a slightly longer ground because it requires me to take your lordships to the judgment. That requires me to find the core bundle. My lord, in the core bundle, the judgment starts at page A93.
Yes.
And what we find after the recitation of the facts and the grounds and the defence is a section at page A99 in which the judge sets out in some detail, I'm not going to read any of it out, but sets out in some detail the evidence that he had before him, largely in the form of witness statements from the lawyers. And then, on page 104, sets out 3 issues, one of which is whether the defendant has been and remains in breach of the duty owed under section 1932,
Yes.
and includes 3 sub-issues, including has the claimant voluntarily ceased to occupy as her only or principal home.
But my sense, Mr. Bailey, is from paragraph 37, read as the whole, that the judge was distilling these 3 issues from what he understood, the claimant to submit in the detailed statement facts and grounds, and the defendant to submit in the detailed grounds of resistance.
Yes. I'm not criticising his classification of the issues.
I see.
I'm just trying to identify where we are in the judgment when we come on to the
I see.
later parts.
Right.
And then in relation to issue 1, is the defendant in breach of duty? He says what he's going to look at. And then comes to submissions on page 106 as to whether suitable accommodation has been made available.
Right.
And at paragraph 50, we get to his decision section. And I can pick it up.
Well, can we just see how he formulates your submission?
Yes.
Because it may not be accurate. He says, Mr. Manning says, the offers were all offers of suitable accommodation. That appears to be an invitation to the judge to say, yes or no. Do I agree that they're offers of suitable accommodation? Whereas it might have been a different question if the submission had been, they were all offers of accommodation which the local authority could reasonably regard as suitable.
Lord, yes, I would submit that I accept the judge at paragraph 50. That's the way he has expressed it. But in my submission, it was clear at the hearing that, I mean, I won't give evidence to this court, but that the local authority's position was it was entitled to have reached the decisions it did, and that it had decided that the decisions were suitable, that the offers were suitable.
But what I'm asking you, and it doesn't require you to give evidence, simply can you tell this court whether it's accurate when he says that your submission was that all offers of suitable accommodation, was that your submission, or was it instead your submission that the local authority had made offers of accommodation which it was entitled reasonably to view as suitable?
The latter.
Right.
It may be that the paragraph 50 would have been accurate if it had said were all offers that the authority was entitled to regard as suitable.
Yeah.
I think your position on both the point we've just dealt with and this one is at A134, isn't it? Summarised in one paragraph of the skeleton. Paragraph 11.
Yes.
Yes. So you were taking us through the judgment at 109.
My Lord, yes. I was simply going to point out that at paragraph 52,
Yeah.
the judge finds that the defendant did accept that as at the 4th of June, which was the date that the respondent moved in,
Yeah.
Holden Close in the condition in which it then was not suitable for accommodation. And I find this for the following reasons, and it sets out his reasons, including at C, that by their letter dated the 4th of June, while the defendant did not specifically accept that Holden Close was unsuitable, the letter nonetheless said that there were problems with it and that measures were being taken to address those. And he says at 53, Mr. Manning argued that the provision of the commode downstairs bed, the referral to an occupational therapist for a care plan, providing for hygiene until the lift was installed, made Holden Close suitable, at least in the interim, until the lift was installed. He then sets out various arguments that were made against that by my learned friend. and at 55, Mr. Manning's argument is that 7 Holden Close was suitable, at least from the 4th of June or shortly thereafter, by virtue of the agreement to install a new lift and the provision of the package in the interim period while the adaptations were completed. And he says, in principle, I accept that even though Holden Close was originally offered on the 6th of May as being suitable without any suggestion that adaptations would be carried out, nonetheless, it could become an offer of suitable accommodation by the offer to carry out adaptations and to provide interim measures which mitigated the unsuitability while those adaptations were being carried out. It follows from that conclusion that Holden Close was not suitable, at least until the offer to make adaptations and put in place mitigating measures was made on the 4th of June. So he seems to have been concluding that the accommodation was not suitable until the offer was made on the 4th of June, but might have been suitable after. And he then continues, in order for me to accept Mr. Manning's submission that Holden Close was rendered suitable by the defendant's offer, I would need to be satisfied that the temporary arrangements to provide for Ian's hygiene, toilet and sleeping, while they clearly would not be ideal, were arrangements which it would be reasonable to expect Ian to endure during the period when the adaptations were being carried out. Now, if that had meant which a local authority was entitled to decide were reasonable for him to endure while the adaptations were carried out, then I would submit that that was correct.
Isn't that in substance what the judge is saying?
Well, in my submission, it's not, because when we come to paragraph 60, he says this: in my judgment, 7 Holden Close is not now and never has been suitable. I come to this conclusion for the following reason. In my judgment, the temporary arrangement would not make the property suitable for a period of anything more than the 4-week period that the defendant originally suggested it would take to carry out the adaptation, given the significant inconvenience and the indignity that Ian would suffer during that period. It's taken longer than 4 weeks to complete the adjustments. Manning suggests the defendant's done its best, but has been let down by suppliers. It was the defendant which provided the 4-week estimate. There's no evidence before me that the defendant checked delivery times, etc., 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 etc. And so, what in my submission the judge has done is to make a decision not whether a reasonable authority could have decided that the accommodation was suitable, but he's made his own decision that the accommodation is not now and never has been.
Well, can we just look at the top of page 113?
Yes,
Which is the end of paragraph 60, where the judge makes the period of time for which Ian would be expected to endure the temporary arrangements is therefore well beyond, in my judgment, a reasonable period during which he could be expected to endure. Could it not be said that that's echoing the way in which the judge had posed the question for himself at paragraph 57, and that he is in substance applying a reasonableness test rather than simply saying what he would do if he were the public authority?
Well, my lord, what I would submit is that reading the judgment of this part of it as a whole,
Yes.
what the judge was doing was saying how long would be reasonable for a person to have to live like that, and forming his own view about that, not saying how long could a public law decision maker charged with making that decision have lawfully come to the conclusion.
I'm afraid I just don't understand that distinction. I mean, that sounds like angels dancing on the head of a pin. If the ultimate litmus test is reasonableness, then in what meaningful sense has the judge simply substituted his own view of the merits for the local authority?
Because he has taken his own view as to what is reasonable.
What else is a judge supposed to do on judicial review? If we ask ourselves the question whether a local authority has acted reasonably, what are we supposed to do?
Well, my lord, in these sorts of cases, the courts frequently pose the question to themselves. That the issue is not what the judge would regard as the reasonable period or the reasonable response,
Yes.
but what the local authority, even if the judge disagreed that that was reasonable, could lawfully, in its own decision-making powers, conclude was a reasonable period. Now, I appreciate the point my Lord is making, which is that if it's reasonable, it's got to be reasonable. If it's got to be reasonable, it's got to be reasonable. And that in deciding whether or not a local authority has exceeded the Wednesbury bounds of reasonableness, a decision has to be made about what's reasonable. But my submission, it's not a semantic point, because the question is not whether Judge Rawlings thought that the accommodation offer was suitable. It was whether Judge Rawlings was able to conclude that the local authority were not entitled to have reached a view that they...
Well, can I make sure I'm understanding this? Because I understand what you say about the end of paragraph 60, well beyond, and all the rest of it. But as you've pointed out, this judge was in an unusual position. He didn't have a reasoned decision of the local authority to review. So far as I understand, he didn't have a decision from the local authority which said, we have judged that approximately the amount of time that's going to be required for this paraplegic gentleman to endure these unsatisfactory conditions is X, and we think that's reasonable so that we can carry out the adaptations to the property. Was there anything of that kind before the judge?
No, there was the letter of the 4th of June, which perhaps I should take the court to. But no, there was not an up-to-date review decision or decision of any kind.
Well, any evidence of internal decision-making which suggested they'd actually looked at these considerations and had come to a view, a judgment on it?
Well, my Lord, the difficulty was compounded by the fact that the judge had excluded some of the evidence that the authority had put in late. I can't
because
get
it
around
was late.
Yes, I know. I can't get around that. I'm not criticising the judge in saying that. I'm simply owning up to the fact that that was an additional difficulty. Because while a witness statement from the local authority had been submitted and an application had been made for it to be admitted late, that application was unsuccessful.
Well, those paragraphs are not in our bundle,
No, they're not.
so we don't know whether it answers the question I've raised with you.
No, but in any event, the judge wouldn't have been looking at them anyway if he excluded.
But as I understood it, you weren't suggesting that the decision-making process of Birmingham, in this case, included consideration of these issues.
Well, we were suggesting that because one of the things we were saying was that the letter that had been written, that was in the bundle, was clearly saying that the property was not regarded as
Yes, sorry, I was focusing on, as my lord was, on a particular question, namely the length of time. It was going to be suitable once adapted.
Yes.
That begs the question, the length of time for which this gentleman would have to stay in unsatisfactory conditions.
Yes.
I was asking you whether that factor was assessed by the local authority.
It was assessed, but the evidence of that was not before the judge. Because the witness statement which set it out was excluded.
Yes.
In part. The part that was admitted was the part that set out what had happened after the date at which the witness statement should have been put in, and dealt with timescales for the provision of lifts and matters of that sort. So, no, I mean, look, it is no part of my case that every part of the authority's processing has been seamless and every part of its response to this challenge was conducted in a way that was perfect. Plainly, mistakes were made, evidence was put in late, and I accept entirely that that did not assist the judge. However, what I submit is that that does not lead to a judicial entitlement to entertain a case that should have been dealt with by a different statutory remedy, or in entertaining it to adopt an approach which does not accord the decision making of the authority the respect it deserves. Now, I mean, if we're in a position where the judge says, well, how am I to know what the authority's decision is because no one's told me, that, then my submission would be, well, that is yet a greater reason why the alternative remedy should be left.
I thought we were on a different ground.
I am,
Yeah,
but
right.
but in my submission, they,
All right.
in many ways, they're different sides of the same
Okay.
criticism.
Understood. Okay. Can I ask you this?
Oh yes.
Since we're on the ground, which is concerned with whether the judge applied public law principles or not, what would follow? Suppose we were to accept your argument on this issue. What would follow? Would you invite us to remit to the High Court to redetermine the issue in accordance with the correct legal principles, or do you invite this court to substitute its own decision for what the judge ought to have held?
Well, in my respectful submission, again, that then gets into the territory of whether there would be any, in relation to the question of whether the declaration should have been made. It seems to me that the appropriate court, bearing in mind what the evidence before this court is and what it was before the court below, would be to remit. But if this court felt that it had sufficient material to reach its own decision, in a way I would be content with that course.
What if we took the view that by that stage, really, one has to call a halt to all of this? This is becoming, even if it wasn't academic, to entertain the appeal. There's no practical purpose to be served in remitting it now.
Well, that may be right.
But in any event, if you're right, you submit, you would still have achieved something of practical value, which is the discharge of the declaration.
Okay.
So that would be set aside.
Yeah.
On the basis that the judge never asked himself the right question, which is, what am I here for? What am I doing on this application for judicial review? That's a fundamental error of approach, and therefore the declaration he granted you submit must be discharged.
And that would be sufficient in the circumstances of this case.
I see.
Bearing in mind that the mandatory order made is no longer pursued.
I see.
My Lord,
Right.
in relation to the judge's judgment, we've not appealed his decision specifically on Langdon Walk because it didn't seem to be proportionate to deal with that. But in relation to his conclusion on the Ladbroke Hotel, we also take paragraph 68 of the judgment as an indication of the approach that he adopted. I am not satisfied that the offer of the hotel was an offer of suitable accommodation. The point raised by the solicitors about the absence of ramps was never answered, and I'm not satisfied there was suitable or usable access. The hotel was at best accommodation which could only be suitable for a temporary period. The defendant agreed to arrange an OT to visit the hotel to assess its suitability, and pending that happening, the move would be rescheduled. There's no report on page 115 on the suitability, and the defendant did not reschedule a moving date, which reinforces my view that the hotel was not suitable.
Another way of perhaps recasting this is that given the material which wasn't being provided by the council, he was saying, well, these factors weren't taken into account.
Well,
They didn't have an OT report. Concerns had been raised about the hotel. Photographs had been sent that there was no access at the front and no access at the rear, I think. And that led to the need for an OT report. And he was saying, well, where is it?
yes, he was saying that, but it's my submission that he was raising those issues in the context of his view, as expressed by him, that that he was not satisfied that the offer was suitable.
I mean, this is, if I've understood correctly, and you will put me right if I'm not, this is also in the context of there being evidential uncertainty as to how long the adaptations are going to take. There was no timeline.
There was some evidence of a timeline. There was no finite. I mean, there was no definite end date. I have to accept that.
Yeah.
There was no, but there was.
Which might affect a view taken by a local housing authority about the suitability of even temporary accommodation for someone with this disability.
It might. But in my submission, the question of the alternative remedy arises in relation to this as well, this accommodation as well. But aside from that, we submit that the way that the judge has dealt with this was simply wrong. I mean, my lords, you will obviously read his judgment and form your views about whether that is a valid criticism of him or not. I'm not sure that I can expand on it in that context. I've taken your lordships to the relevant sections of the judgment.
Yes. Right.
In relation to the question, the equivalent question as to discharge of duty.
Are we still in the same grounds of appeal?
It's the equivalent ground of appeal in relation to the discharge point. So it's rather than ground 6, which I was addressing,
Yes.
it's ground 3, but it's essentially the same argument.
It is your argument, in a nutshell, again, the judge fell into the fundamental error of approach that he never asked himself the right question, which is a judicial review question, and instead formed his own view about issues
Yes.
of substance. We understand that argument.
My Lord, in my submission, that the same is evident, perhaps even more clearly, at page A121 in relation to the discharge point.
121.
Paragraph 82. I'm not in any event satisfied, he says at the very top of page A121,
Yeah.
I am not in any event satisfied that the claimant has in fact ceased to occupy 7 Holgate Close as her only or principal home.
Yes.
For the following reasons, and he lists a number of factual matters. As a result of which, he says, for example, in paragraph 82C at the bottom of that page, the evidence that the claimant has ceased to occupy Holden Close as her only or principal home is inconclusive. I find it's not sufficient to persuade me that the claimant should be disbelieved when she asserts that she moved into room 1 for a few days and continues to treat Holden Close as her only or principal home. And we say that is a classic error of approach. Because plainly, what the judge should have been looking at was not whether or not he thought that her witness statement to the Judicial Review Court was correct or should be believed. He should have been taking the view when the authority discharged or the authority treated the duty they had an end. Were they legally entitled to do that?
There's a lot of law on the making of decisions, findings of fact review, it's generally unnecessary and inappropriate. Generally speaking, of course, there's no oral evidence in judicial review proceedings. That's not the only reason why the Judicial Review Court does not usually make findings of fact. There are many reasons why it doesn't. But what I want to ask you, Mr. Manning, is were these fundamental points about the nature of judicial review procedure put to the judge?
Well,
as I read paragraph 82, for example, and this is certainly your submission, he appears to be doing what a civil jurisdiction judge does.
yes,
If it's an action for negligence, for example, or trespass to land, or whatever it is, you just decide questions of fact on the evidence before you. But what I'm asking you is, did you make it clear to the judge that he wasn't sitting in the county court, for example, deciding facts for himself?
My lord, the way that the argument was put formed the local authority by me was that she said one thing, the respondent said one thing, the authority's evidence was different, and the authority was entitled to rely on its own evidence. I didn't say to him specifically. And this was a point his honour took in refusing permission. I don't think I ever said to him specifically, my lord, in judicial review proceedings you have to decide this on a public law basis. But that was because he gave no indication at the hearing
Well, there's a more specific point.
that he wasn't going to do that.
Forgive me, there's a more that's generally about public law, but there's a more specific set of authorities, well-trodden case law, to the effect that if there's a dispute of fact in judicial review proceedings, generally speaking, first of all, the burden lies on the person who asserts something to prove it, but secondly, generally speaking, you accept the evidence of the defendant, because, unless there's, for example, an internal incoherence, or there's some documentary evidence which undermines. But that's not necessarily obvious to any judge sitting in the administrative court. They may need to be told that there's authority on this, that this is the approach you must take. Was that drawn to his attention?
There was no citation of authority.
No.
It was a point that perhaps, in retrospect, I took too much for granted.
Well, is there another dimension as well, I think, affecting this hearing? As I understand it, an important part of your case was to resist the application for a mandatory injunction, a final one.
Oh, dear.
And that involved the application of the Supreme Court's decision in IMA.
Yes.
And that involved, in part, looking at the question of impossibility of complying with the duty.
Yes.
Don't you then get absorbed into a discussion as, I won't call it the merits, but it is the merits, isn't it, to some extent?
Well,
it was impossible. There the court is actually policing the compliance with the duty in deciding whether or not it will grant relief.
I accept entirely that was one of the issues we raised in relation to the question of whether or not we'd come close enough to comply with the duty.
So the judge had to decide whether you met the imam test and impossibility and so on.
Yes, he did.
For himself.
But all I would say, if I may, my lord, respectfully, is that in relation to the question of whether any duty at all was owed, it was the claimant, it was the local authority's argument that there wasn't any duty to enforce by mandatory order because by that stage it had ceased to happen.
Well, going forward, in fact, that's one of the things we might need to come back to in the form of the declaration. I mean, it's looking backwards, it's looking to the past in part.
Yes. But in my submission, so far as the judge was dealing with the question of whether or not the local authority had been entitled to conclude that the duty had come to an end, insofar as he decided that on the basis of the construction of the section, he was entitled to do that. We say he reached the wrong conclusion, and that's another ground of appeal. But insofar as he was looking at whether or not, as a matter of fact, the criterion established by Section 193(6)(d) had been factually met, that should not have been a difficult exercise to do on the right basis, because that is a conventional argument that will arise in a judicial review claim. So the two issues, I suppose what I'm saying, we're not merging or blending here. We were dealing with the question of, was there a duty owed at all? And then, only if there was, we got to the point of arguing about whether or not in policing it all, the court should, in its discretion, grant mandatory relief or should
Right.
refuse to do so.
Okay, thank you very much. Can I, first of all, let me just point out that clock is 3 minutes slow, but we're going to adjourn now. Can I ask you how much longer you will need?
I will try and limit it after the adjournment to 35 minutes.
Can I urge you to be 30 minutes and no more?
I will.
All right, because we need to leave an adequate time for the respondent submissions, and I have in mind roughly an hour and a half.
My lord,
So if you were to finish by 2:30 and you were to finish by 4 o'clock, that would mean there's a short opportunity for you to reply. I hope that's fair to everyone.
Yes, I will
Very good.
ensure that
We look forward to hearing you again at 2 o'clock.
Court rise and stay cool.